For this video, we are going to discuss rights of person arrested, detained, or under custodial investigation. This is based on Republic Act 7438 and relevant jurisprudence. What is the scope of RA 7438? The law covers a situation where a person is arrested, detained, or under custodial investigation. When you say person, it refers to any person, regardless of age, gender, status, work, race, religion, or political belief, because in our criminal jurisdiction, we subscribe to the principle of generality. Arrested covers arrests without warrant or by virtue of a warrant of arrest. When you say detained, the detention here is either with legal ground under Article 125 or without legal ground under Article 124. And when you say custodial investigation, it is a questioning initiated by law enforcement officers after a person has been taken into custody or deprived of freedom of action in any significant way. When is a person deemed to be under custodial investigation? A person is deemed to be under custodial investigation where an investigation is no longer a general inquiry into an unsolved crime but has begun to focus on a particular suspect who is taken into custody by the police or other law enforcement agents who carry out a process of interrogation that lends itself to elicit incriminating statements, as ruled in the case of People versus Mara. So take note of some keywords here. There is already a suspect, meaning to say the police officers already have a suspect in mind, and this presupposes that it relates to the commission of a crime. And this suspect, whom they suspect of committing the crime, is taken into custody. And once the suspect is already in their custody, they start to ask or interrogate the said suspect in the hope of eliciting from him incriminating statements or making him admit to the commission of a crime. That is the atmosphere of a person who is under custodial investigation. For example, police officers suspected X of killing Y. They went to X's house and forced him to go with them to the police station. At the police station, they started questioning him, forcing him to admit to the crime. Here, X is deemed to be under custodial investigation. Example number 2. Suppose the police officers merely asked X incriminating questions without making him admit to the crime. Question: is X still deemed to be under custodial investigation? The answer is yes. It is not necessary that X admits or is forced to admit to the crime. Asking incriminating questions is enough. Example number 3. Police officers suspected X of killing Y. They then went to X's house to inquire about the incident. Even though they suspected X as the culprit, they, however, neither asked him incriminating questions nor forced him to admit to the crime. They did not even take X into custody. Here, there is no custodial investigation because there is only a general inquiry into an unsolved crime. It does not meet the requirements of a custodial investigation. Example number 4. Police officers called up X by phone and invited him to come to the police station in connection with a crime they suspected X to have committed. X, fearing that something might happen to him if he refused, acceded to the invitation. At the police station, they interrogated X. Here, X is deemed to be under custodial investigation because under the last paragraph of Section 2 of Republic Act 7438, the term custodial investigation shall include the practice of issuing an invitation or a so-called invitation to a person who is investigated in connection with an offense he is suspected to have committed. So kahit na hindi siya pinuntahan sa bahay niya or he was not forcibly taken or brought to the police station, even if it was made under the auspices of a so-called invitation, pero may kasamang intimidation na yon dahil police officers yung nagbigay ng invitation such that the person is forced or intimidated into going to the police station or to some other place designated by the police officers, that is subsumed or is included under the term custodial investigation. And in such a case, the person subjected to interrogation can invoke the so-called Miranda rights, as we will discuss in the subsequent slides. Section 12, Article 3 of the 1987 Constitution states, any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. Any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. In the case of People v. Guting, the investigation in Section 12, Paragraph 1, Article 3 of the 1987 Constitution pertains to custodial investigation. And we already know, as I have already mentioned, that custodial investigation commences when a person is taken into custody and is singled out as a suspect in the commission of a crime under investigation, and the police officers begin to ask questions on the suspect's participation therein, and which tend to elicit an admission. Take note of that. Now, in People v. Aison, the Supreme Court kind of took judicial notice of what happens in a custodial investigation or the atmosphere in a custodial investigation. It said, after a person is arrested, detained, or under custodial investigation, a confrontation arises which at best may be termed unequal. The detainee is brought to an army camp or police headquarters and there questioned and cross-examined not only by one but as many investigators to break down his morale. He finds himself in strange and unfamiliar surroundings. They employ all the methods to extract the truth, or what may pass for it, out of the detainee. Most detainees are unlettered and are not aware of their constitutional rights. And even if they were, the intimidating and coercive presence of the officers of the law in such an atmosphere overwhelms them into silence and submission. So, ma-imagine mo ngayon kung ano yung nangyayari during a custodial investigation. Hindi patas dahil yung detainee or yung person na arestado or naka-detain or under a custodial investigation is being questioned not just by one investigator but many investigators. Or he may be surrounded by several investigators at the same time, and then he will be asked incriminating questions under duress, usually under duress. That is the reason why there is a need to protect his rights under this atmosphere. Given the atmosphere of a custodial investigation, that is why the Constitution and Republic Act 7438 adopted the so-called Miranda rights, which was taken from the U.S. landmark case of Miranda versus Arizona. Miranda summarized the procedural safeguards laid down for a person who is under custodial investigation. He must be warned prior to any questioning that he has the right to remain silent, that anything he says can be used against him in a court of law, that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. Opportunity to exercise those rights must be afforded to him throughout the interrogation. After such warnings have been given, such opportunity afforded him, the individual may now knowingly and intelligently waive these rights and agree to answer or make a statement. But unless and until such warnings and waivers are demonstrated by the prosecution at the trial, no evidence obtained as a result of such interrogation can be used against him. This is now jurisprudence in the case of People versus Aison. Now, what happened in that case of Miranda versus Arizona? The U.S. Supreme Court in that case ruled that detained criminal suspects prior to police questioning must be informed of their constitutional right to an attorney and against self-incrimination. The case began with the 1963 arrest of Phoenix, Arizona resident Ernesto Miranda, who was charged with rape, kidnapping, and robbery. Miranda was not informed of his rights prior to the police interrogation. During the 2-hour interrogation, Miranda allegedly confessed to committing the crimes, which the police apparently recorded. Miranda, who had not finished 9th grade and had a history of mental instability, had no counsel present during such interrogation. At trial, the prosecution's case consisted solely of his confession. Miranda was convicted of both rape and kidnapping and sentenced to 20 to 30 years in prison. He appealed to the Arizona Supreme Court, claiming that the police had unconstitutionally obtained his confession. The court disagreed, however, and upheld the conviction. Miranda then appealed to the U.S. Supreme Court, the U.S. Federal Supreme Court, which reviewed the case in 1966. The Supreme Court, in a 5-4 decision or 5-4 decision written by Chief Justice Earl Warren, ruled that the prosecution could not introduce Miranda's confession as evidence in a criminal trial because the police had failed to first inform Miranda of his right to an attorney and against self-incrimination. In the case of People versus Andan, the Supreme Court made the following pronouncement. It said, "The said rights are guaranteed to preclude the slightest use of coercion by the state as would lead the accused to admit something false, not to prevent him from freely and voluntarily telling the truth." So kung gusto ng isang akusado or ng detenado or ng person under investigation to tell the truth, either because he was struck by his conscience, that's why he wants to confess to the commission of the crime, then he must be allowed to do so. The so-called Miranda rights can only be invoked when there is some coercion, even the slightest use of coercion by the state to make the person under investigation or to make the accused confess to a crime he did not commit. Or even if the accused or the person under investigation indeed committed a crime, if he doesn't want to confess, then he must not be forced to do so. that is where the Miranda rights are to be invoked, not when the accused or the person under investigation wants to freely and voluntarily tell the truth. Now, what are the rights of a person arrested, detained, or under custodial investigation in Republic Act 7438? The first right available to such a person is the right at all times to be assisted by counsel. This is so found in Section 2A of the said law. Second is the embodiment of the Miranda rights or the adoption of the so-called Miranda rights in the said law. And what are these Miranda rights which are so provided in Section 2B? The first Miranda right is the right to remain silent. This means the right to literally refuse answering any question. His refusal will not be used against him. The person under investigation, the person arrested, the person detained can remain silent for as long as he wants to. That is his right. He cannot be forced to speak. And to repeat, his refusal to speak or to answer the questions propounded by the investigating officer or the police officer will not or cannot be used against him, or it will not be taken against him, because it will not be considered as evidence of guilt. In People versus Caguioa, the Supreme Court said that if the person indicates in any manner and at any stage of the process that he wishes to consult with a lawyer before speaking, there can be no questioning. So, kailangan talaga may lawyer na mag-a-assist sa kanya if he wants to answer the questions propounded by the investigating officer. Until and unless there is such a counsel, then there can be no questioning. Likewise, if the individual is alone and indicates in any manner that he does not wish to be interrogated, the police cannot question him. The mere fact that he may have answered some questions or volunteered some statements on his own does not deprive him of the right to refrain from answering any further questions until he has consulted with an attorney and thereafter consents to be questioned. The next Miranda right is the right to have competent and independent counsel, preferably of his own choice. If such a person cannot afford the services of his own counsel, he must be provided with a competent and independent counsel by the investigating officer. In People versus Mojello, the Supreme Court had occasion to describe what the phrase preferably of his own choice means. The phrase preferably of his own choice does not convey the message that the choice of a lawyer by a person under investigation is exclusive as to preclude other equally competent and independent attorneys from handling the defense. Otherwise, the tempo of custodial investigation will be solely in the hands of the accused, who can impede, nay obstruct the progress of the interrogation by simply selecting a lawyer who, for one reason or another, is not available to protect his interest. So that pretty sums up what the meaning of the phrase preferably of his own choice is. Meaning to say, as much as possible, it should be the choice of the person under investigation or the accused that should be afforded. The choice of the lawyer whom he wants to represent him or assist him during the custodial investigation. But if the lawyer of his own choice is not available at the time, or he cannot afford the services of that lawyer, then it does not prevent the state from providing him with another lawyer who is equally or also competent and independent. and who can rather adequately assist him during the custodial investigation. So that is the meaning of the phrase preferably of his own choice. So kung available yung lawyer of choice ng accused or ng person under investigation, then yun yung susundin. Yun yung kukunin. But kung wala, hindi siya available, dapat siyang bigyan ng ibang lawyer na competent at independent din na who can adequately explain to him the consequences of his decision to answer the questions propounded by the investigating officer. While the choice of a lawyer is naturally lodged in the police investigators, the suspect has the final choice, as he may reject the counsel chosen for him and ask for another one. A lawyer provided by the investigators is deemed engaged by the accused when he does not raise any objection against the counsel's appointment during the course of the investigation, and the accused thereafter subscribes to the veracity of the statement before the swearing officer. So, ang ibig sabihin dito is if hindi nag-object, let's say hindi available yung lawyer of choice ng accused or person under investigation, or kahit na available, he cannot afford the services of the lawyer of his own choice, such that the investigating officer had to provide him with an equally independent and competent lawyer. If he did not object to such decision of the investigating officer to provide him with another lawyer, or he did not object to the lawyer provided by the investigating officer who represented him during the custodial investigation, and he makes an incriminating statement relative to the questions propounded by the investigating officer, and he subscribed thereafter to the veracity of the statements which he made in the presence and with the assistance of that lawyer provided by the investigating officer, then that will not invalidate his confession or admission or whatever answer he may have given during the custodial investigation. The right to counsel at all times is intended to preclude the slightest coercion as would lead the accused to admit something false. This is very important. The lawyer, however, should never prevent an accused from freely and voluntarily telling the truth. In People versus Rapeza, the lawyer called to be present during the custodial investigation should, as far as reasonably possible, be the choice of the individual undergoing questioning. If the lawyer is furnished by the police for the accused, it is important that the lawyer should be competent, independent, and prepared to fully safeguard the constitutional rights of the accused, as distinguished from one who would merely be giving a routine, peremptory, and meaningless recital of the individual's constitutional rights. In People versus Cachuela, the Supreme Court emphasized that the lawyer must be able to advise and assist his client from the time the latter answers the first question asked by the investigating officer until the signing of the extrajudicial confession, if there is any. The lawyer should ascertain that the confession is made voluntarily and the person under investigation fully understands the nature and consequences of his confession in relation to his constitutional rights. The third Miranda right is the right to be informed of such rights. The right to be informed of the right to remain silent and to counsel contemplates the transmission of meaningful information rather than just the ceremonial and perfunctory recitation of an abstract constitutional principle. It is not enough for the interrogator to merely repeat to the person under investigation the provisions of Section 12, Article 3 of the Constitution. He must explain the effects of such provision in practical terms. For example, what the person under interrogation may or may not do, and in a language the subject fairly understands. The right to be informed carries with it a correlative obligation on the part of the police investigator to explain, which results in the subject's understanding of what is conveyed. Since it is comprehension that is sought to be attained, the degree of explanation required will necessarily vary and depend on the education, intelligence, and other relevant personal circumstances of the person under investigation. In further ensuring the right to counsel, it is not enough that the subject is informed of such right. He should also be asked if he wants to avail of the same, and should be told that he could ask for counsel if he so desires, or that one could be provided to him at his request. This was decided in the case of People versus Nicandro. So what is the relevance of this right to be informed of such rights? This is very important because if the person under investigation does not know that he has the right to remain silent, or he has the right to have a competent and independent counsel, preferably of his own choice, then how can he invoke such rights? So, at the first instance, the police officer who takes him into custody for the purpose of conducting a custodial investigation on him should inform him of such rights. Otherwise, whatever confession he makes, because he does not know that he has the right to remain silent, or he has the right to have competent and independent counsel of his choice, will be invalidated or will be voided. So this is very important. The right to be informed of such rights. So this is what? To inform, adequately inform the person under investigation that he possesses such rights. And what are these rights? The right to remain silent and the right to have competent and independent counsel of his choice, or preferably of his choice. And also, take note of the requirement or reminder of the Supreme Court. It presupposes the transmission of meaningful information rather than just the ceremonial and perfunctory recitation of an abstract constitutional principle. Hindi enough yung parang pinaparot lang ng police officer yung Miranda rights. Sasabihin lang niya, you have the right to remain silent and you have the right to competent and independent counsel of your choice. That is not enough. He must be what? He must ensure that the person under investigation or the person arrested or detained understood what he meant by right to remain silent and right to counsel. Now, aside from the Miranda rights, the person arrested, detained, or under custodial investigation also has the right to be assisted by counsel before he is made to sign the custodial investigation report to be prepared by the investigating officer, if there be any. This is so provided in Section 2C of Republic Act 7438. Such report shall be read and adequately explained to him by his counsel or by the assisting counsel, provided by the investigating officer in the language or dialect known to such arrested or detained person. Otherwise, such investigation report shall be null and void and of no effect whatsoever. Another right which is found in Section 2F, supra, is the person's right to be allowed visits by or conferences with any member of his immediate family or any medical doctor or priest or religious minister chosen by him or by any member of his immediate family or by his counsel or by any national non-governmental organization duly accredited by the Commission on Human Rights or by any international non-governmental organization duly accredited by the Office of the President. Now, take note that not all types of investigatory situations are classified as custodial investigations where these rights may be invoked. Meaning to say, merong mga klaseng investigation na ginagawa ang mga pulis na although considered as an investigation or part of the investigatory process, but they are not considered part of custodial investigation because it is only during a custodial investigation where the Miranda rights may be invoked by the person subjected to such investigation. So for example, in the case of People versus Gamboa, the Supreme Court held that subjection to paraffin test does not require that the right to have competent and independent counsel be afforded, as this is necessary only in testimonial compulsions, not when it is the body of the accused which is proposed to be examined. So here, although subjecting a person under investigation or a person arrested to paraffin test to determine the presence of gunpowder will kind of incriminate the person in relation to the crime he is suspected to have committed. At this stage or at this point, it is not considered as part of custodial investigation because the Miranda rights are only invoked or only necessary in testimonial compulsions. When it is the body of the person who is examined or being examined, the Miranda rights or invocation of the Miranda rights will have no place in such a scenario. And this happens also in the case of drug tests. When a person is subjected to a bypass operation, arrested pursuant to such bypass operation, and subsequently he is subjected to drug testing. Whatever the result may come out of that examination can be used in evidence against him, even if at the time of such examination he was not afforded his right to counsel. Because as I said, it is not considered a part of the custodial investigation process, and more importantly, the Miranda rights may only be invoked when it comes to testimonial compulsion. Another example would be in the case of police lineups. In the case of People versus Rueras, the Supreme Court reiterated the view that police lineups are not part of custodial investigation and therefore the right to counsel cannot be invoked at this stage. So if, for example, a person is subjected to a warrantless arrest for the alleged commission of the crime, let's say X was arrested without warrant because he was suspected of shooting another person, and X was subsequently, along with the others, placed or put in a police lineup where a witness unfortunately identified X as the one who shot the victim. In that scenario or in that situation, while it is investigatory in nature, in the case of People versus Rueras, it is not considered as part of custodial investigation. And Therefore, the right to counsel, X in that example, cannot invoke his right to counsel, or he cannot interpose the defense that the identification made by the witness is inadmissible in evidence against him because it is in violation of his Miranda rights. That is not the case because, to repeat, a police lineup is not part of custodial investigation. Can the Miranda rights be waived? The answer is found in section 12, last sentence of section 12, paragraph 1, article 3 of the 1987 Constitution. The answer is, these rights, meaning the Miranda rights, may not be waived unless made in writing and in the presence and assistance of counsel. Meaning to say, if the accused wishes to waive his Miranda rights, he can do so, but he can only do so if he waives it in writing or waives them in writing, and the waiver must be made in the presence and with the assistance of a counsel of his choice. Let's talk about the extrajudicial confession as provided in Section 2D of Republic Act 7438. Ano ba itong extrajudicial confession? But before that, allow me to impart to you the difference between the word confession and admission. A confession is a declaration made at any time by a person voluntarily and without compulsion or inducement, stating or acknowledging that he had committed or participated in the commission of a crime. On the other hand, admission is usually applied in criminal cases to statements of fact by the accused which do not directly involve an acknowledgement of the guilt of the accused or of criminal intent to commit the offense with which he is charged. This was decided in the case of U.S. versus Corrales. So, admission is of a lesser degree compared to confession because confession is basically confessing to the commission of a crime, no? Admitting the commission of a crime, or admitting or confessing or acknowledging his guilt. When you say extrajudicial as applied to confession, extrajudicial confession, it means a confession made outside of court or executed without the intervention of a court. Because there is such a term as judicial confession. When you say judicial confession, it is an admission of guilt or acknowledgement of guilt made in open court by the accused who is charged of a crime which is pending in that court. But when you say extrajudicial, there is no case yet, or even if there is a case filed against the person, he makes a confession outside of the court. Now, what are the requisites of a valid extrajudicial confession? To be admissible, an extrajudicial confession must satisfy the following requirements. Number 1, the confession must be voluntary. Number 2, it must be made with the assistance of a competent and independent counsel. Number 3, it must be in writing. This was ruled or pronounced in the case of People versus Cachuela. In People versus Muleta, the Supreme Court stated that to be acceptable, it must conform to constitutional requirements. A confession is not valid and not admissible in evidence when it is obtained in violation of any of the following rights of persons under custodial investigation. Meaning to say, when you say it must conform to constitutional requirements, there must be no violation of the Miranda rights of the accused or the person under investigation. Under custodial investigation, I mean. Because if there was already a violation of the rights of the said person during his custodial investigation, even if there was no or he did not make yet an extrajudicial confession, whatever extrajudicial confession he makes will no longer be considered valid. That is the point there. Now, if the extrajudicial confession satisfies these constitutional standards, meaning there was no violation of the Miranda rights of the accused or of the person under custodial investigation, it is subsequently tested for voluntariness. Voluntariness, I mean. Voluntariness meaning if it was given freely, without coercion, intimidation, inducement, or false promises. And thereafter, credibility, if it was consistent with the normal experience of mankind. Take note of that. In People versus Satori, the Supreme Court defined what the word voluntary means. It means that the accused must speak of his free will and accord, without inducement of any kind and with a full and complete knowledge of the nature and consequences of the confession. And when the speaking is so free from influences affecting the will of the accused at the time the confession was made, that it renders it admissible in evidence against him. Section 2D of RA 7438 further provides that aside from those requisites which I have mentioned, that it must or that there must be no violation of the Miranda rights of the person under investigation, that it must be voluntary, and there must be some credibility in his confession. Section 2 further provides that whenever there is an extrajudicial confession to be made, it must be made in the presence also of any of the parents or elder brothers or sisters or the spouse or the mayor or the judge or the district supervisor or district school supervisor or the priest or minister of the gospel as chosen by him. So any of the persons, it requires the presence of any of the persons enumerated. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. Summing it up, these are the requisites of a valid extrajudicial confession. Number one, it must not be taken in violation of a person's Miranda rights. Second, it must be voluntary and credible. Third, it must be made with the assistance of a competent and independent counsel, preferably of the confessant's choice. Fourth, it must be in writing. And fifth, as I have already mentioned, it must be made in the presence of any of the parents or elder brothers and sisters, etc., as chosen by the confessant, meaning to say the confessant may choose that his parent should be present at the time he makes such extrajudicial confession, or he could choose his wife or his elder brother or sister, as the case may be. Now, what is the effect of the violation of the said rights? Under Section 12, Paragraph 3, Article 3 of the 1987 Constitution, any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against the supposed confessant. Take note of that. This is so because a confession must be given voluntarily, free from any suspicious circumstances tending to cast doubt on the integrity and credibility of the confession. Otherwise, the same cannot be used as evidence in any proceeding against the person who made such confession. This is called in the law on evidence as the exclusionary rule. What are the other rights of a person arrested, detained, or under custodial investigation? In Section 12, Paragraph 2, Article 3 of the 1987 Constitution, it states, and I quote, "No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited." Are there penal and civil sanctions against law enforcers who violate such rights? The answer is yes. And what are the penal sanctions? Under Section 4 of Republic Act 7438, the failure of the investigating officer to inform any person arrested, detained, or under custodial investigation of his Miranda rights, or the failure of the investigating officer to provide the person with a competent and independent counsel will make him liable to a fine of 6,000 pesos or a penalty of imprisonment of not less than 8 years but not more than 10 years or both. Take note of that. And he can also be meted the penalty of perpetual absolute disqualification if the investigating officer has been previously convicted of a similar offense. Also, under the same section, any person who obstructs or prevents or prohibits any lawyer or any member of the immediate family of a person arrested, detained, or under custodial investigation, or any medical doctor or priest or religious minister chosen by him or by any member of his family or by his counsel from visiting and conferring privately with him, or from examining and treating him, or from ministering to his spiritual needs at any hour of the day or in urgent cases of the night, he will be liable for imprisonment of not less than 4 years nor more than 6 years and a fine of 4,000 pesos. Under the revised penal code and special laws, the person who tortures or who makes threats or who employs violence or intimidation against the person under custodial investigation with the end in view of eliciting an incriminating statement from him will be liable, for example, of grave threats under Article 282 or grave coercion under Article 286 or physical injuries under Articles 262 to 266, or the investigating officer or the police officer may be held liable for arbitrary detention in Article 124, or in serious cases, the arresting officer may be charged with attempted or frustrated murder or homicide, or the police officer or investigating officer may be held liable under a special penal law, the Anti-Torture Act of 2009. What about civil sanctions? The investigating officer or the police officer may be held liable in the form of damages in Article 32. Any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages. There are two applicable provisions here. Paragraph 4, which is freedom from arbitrary or illegal detention, and freedom from being compelled to be a witness against oneself, or from being forced to confess guilt, or from being induced by a promise of immunity or reward to make such confession, except when the person confessing becomes a state witness. And take note that whether or not the defendant's act or omission constitutes a criminal offense, the aggrieved party has a right to commence an entirely separate and distinct civil action for damages. This is termed as independent civil actions. So, whether or not the act of the public officer or the police officer who violates the rights of a person under custodial investigation is criminal or not, the aggrieved person or the victim may, regardless of whatever criminal action can be instituted against the offender, the victim or the aggrieved person may file an independent civil action, which is separate and distinct from the criminal action.